adverting to the recovery of certain articles allegedly affected from the appellants during the course of investigation, comma, it is simply observed that these articles do not connect with the accused persons in any manner, comma, hence could not provide the requisite corroboration to the other pieces of evidence. Full stop. It is well settled law by now that one tainted piece of evidence cannot corroborate another piece of evidence. Full stop. As a rule of prudence, it is required that each piece of circumstantial evidence should be supported by an independent corroboration, comma, which shall by itself be sufficient to establish the guilt. Full stop. However, comma, as observed earlier, each circumstance shall be so connected with each other that it should make one complete chain without there any broken link, comma, but in the instant case there are number of broken links in the chain, and this court thinks that on the basis of available evidence the guilty verdict against the appellants cannot be allowed to sustain. Full stop. The evidence in this regard is admissible only if something is recovered in consequence of disclosure on the part of the accused person. Full stop. So this part of evidence is of no use for the prosecution. Full stop. It is also frequently settled that the corroborative piece of evidence is relevant only when primary evidence inspires confidence. Full stop. For the reasons stated supra, this appeal is allowed and the conviction and sentence recorded against the appellants by learned trial court through impugned judgment are set aside and the appellants are acquitted of the charge. Full stop. They are directed to be released forthwith, comma, if not required to be detained in any other case. Full stop.